Your Lordship. Lordship, I am praying for the listing of an unlisted item, Lordship.
What is the next date?
Lordship, it has not been listed here.
It's a fresh matter.
Yes, Lordship.
What is it against? What is
Lordship,
it? What is the matter about?
Lordship, it's a surfacing matter. Actually, I had taken a loan and I had given 2 properties as collateral, Lordship. One of the properties actually has been auctioned off. And after auctioning off, Lordship, the entire loan has been repaid along with a surplus, which is still remaining in my account. Now the bank has annexed both the properties, Lordship. And
Get it listed day after tomorrow.
Lordship, tomorrow they are coming for possession of the properties, Lordship. It may be listed today in the second half, Lordship.
No, not today. Tomorrow.
Tomorrow in the first half, Lordship.
Whenever the matter comes up.
Well, I'm mentioning a phrase PIL, my lord, on Monday, my lord. It is
What is the
very
matter?
urgent, my lord. The issue is very urgent, my lord.
What is the matter?
My lord, the affected villagers' land have been, my lord, forcefully taken by the, my lord, the revenue department of NC Hills, my lord, half long, without following any statutory law. And they are going to
Monday. You have filed it already?
Yes, my lord, 9, my lord, I think.
Daily list for orders, item number 2.
I think the office note in this case. Just check. It's office note. What does it mean? No, behind this. This one. What? Where is that? Where is that acceptance? Let's have a look. I tried. I couldn't find it. Taken that. We had directed the director of education to get the notices. What has happened? We'll pass it over. Ask the register to point out. We are passing it over. We couldn't find the served notices.
Yes.
Pass over. Who is there for the education department in this case? Who is there?
Education is unacceptable. Education. Secondary.
So NJ Katniar received it. What has he done thereafter? Call Mr. Katniar, pass over.
Item number 3.
May it please your lordship.
Yes, please.
My lord, in a writ appeal, my lord, there was order, my lord, we have gone against it to the Honorable Supreme Court, my lord, by open SLP. My lord, then the matter was heard at length, my lord. After that, it was from the petitioner's side, my lord.
You sought liberty to
Yes,
file a
yes,
review.
true,
Yes.
That's true, my lord. Because one point was could not be raised, my lord, during the writ appeal, my lord. Because, my lord, there is a bunch of writ petition decided by the learned single judge. My lord, this in a common judgment, my lord, another judgment was passed where writ appeal 87 was decided.
Yes.
And thereafter, my lord, this particular writ appeal 47 was decided on that particular line.
Right.
My lord, we only thing is that, my lord, the basic core issue in the writ appeal 47 could not be properly addressed, my lord.
47 or 87?
47. 47 is before your lordship, my lord.
Okay. Very well. We'll issue notice to the other side. Issue notice. Mr. Harish Gupta, standing counsel, puts in appearance on behalf of all respondents. On behalf of all respondents, copies of the review petition be provided to him. Sufficient copies of the review petition be provided to him.
Yes.
He prays for It is granted 3 weeks time to complete his instructions.
My lord, may I pray for an interim, my lord? We are.
Absolutely no, sir. Absolutely no. You are in review.
Yes,
That's
Yes.
very limited scope.
yes, my lord. Deeply obliged.
Item number 4,
In this case, the survey has been completed.
Yes.
Your lordship.
You are appearing for ONGC?
My lord,
Mr. Saiwala?
I'm wrong.
You are appearing for the ONGC? All right. So let it go for admission, then what? What do you want?
Admitted.
Already admitted. All right. Then we'll list it for hearing.
Yes.
What else? Mr. Saiwala puts in appearance. Senior counsel, Mr. Saiwala puts in appearance on behalf of the respondents. The service is complete. The writ appeal has been admitted. List for hearing in due course.
item number 5,
Steps for
Lordship, we're taking during the course of the day, steps.
counsel for the petitioner has not taken steps for service upon the respondents numbers 8, 7, 8, and 9. The requisite steps be taken during the course of the day, whereafter process is issued.
item number 6,
6 weeks.
May I please, Lordship?
Yes.
My lord, the petitioner was the respondent, so respondent here of my lord. He was appointed in the year 2004, my lord. And he was granted a 15 days leave, paternity leave, my lord, which have effect from 29/11/2008 to 13/12/2008, my lord.
Yes.
And he required to resume his duty on 14th of December 2008, my lord. And but he overstayed.
Original writ file has been, yes.
He
Yes.
overstayed thereafter without informing the authority. And the court of inquiry declared him deserted on
All right, that is all irrelevant for the reason that what is your stand regarding non-supply of the relevant documents and
My lord,
memoranda?
he admitted that the documents we have
He has
this
stated that
honorable
the
court-
documents were in Hindi. He doesn't know Hindi.
yes,
What
my,
is your stand about that?
my lord, that this honorable court by the order dated
Come to para 9 of the impugned order. What is your response? Para 7 onwards, read. Para 7 onwards. Page 4 of the impugned order.
7, my lord.
Yes.
Paragraph 13 of the writ petition is extracted as below. The petitioner begs to state that the respondent authority did not furnish memorandum of article of charge to the petitioner. The petitioner further states that the respondent authority did not furnish the documents to the petitioner in respect of the charge framed against him. It is pertinent to mention that the disciplinary authority as well as the inquiry officer did not furnish the petitioner following documents: copy of leave application, copy of leave.
All right, leave the
These are
details of the documents. Now come to your response at para number 9.
Nine,
Yes.
my lord, in response to the environment made in paragraph 13 of the writ petition, wherein a specific stand was taken that the memorandum of charge and article of charge were not served on the petitioner. The
Para
respondent
9
in the
on page
affidavit-
5.
Such and such.
Yeah, yes. With regard to, carry on, where your paragraph 13 is extracted. Read that. In this very
Yep.
para 9,
Paragraph 9, that 13, my lord. that
Yes.
With regard to the statement made in paragraph 13 of the writ petition, deponent begs to state that the petitioner neither request to the disciplinary authority nor the inquiry officer to provide the relevant documents to the case, hence his contention
No.
in this paragraph.
was the requirement of providing documents dependent on a request being made or was it your obligation to
Yeah.
provide the documents?
I have filed our affidavit in opposition and I.
This is a part of the affidavit.
Yes,
This
my
is
lord,
from your affidavit.
part of the affidavit.
Yes,
Yes, my
read,
lord.
read from the affidavit, all right. What have you said about para 13?
At page 95, my lord.
Yes, read. Hmm.
95. This is our affidavit.
Yes, read where have you said that everything was provided?
That, my lord, that, para 7, my lord.
Hmm.
That was regard to the statement made in paragraph 7 of the writ petition, the deponent begs to state that the memorandum of charge along with the statement article of charge, statement of imputation of misconduct,
Hmm.
list of documents and list of witnesses was sent to him at his home
Yes.
address
So
by
it's only a
such
list,
and such.
only a
Why
list. Where are the documents? The documents, government is very clear. You did not provide him with the material documents. You say he did not ask for it. Was it a requirement that he should have asked for it?
My lord, here clearly stated that we have sent it by registered post with edit.
You have sent only a list, gentlemen, not the documents as such. Even if your contention is to be accepted, in view of the admission made at para 13, we have no option but to hold that the documents were not supplied.
My lord, he admitted that the memorandum was sent by the respondent authority, but not received by him by another person.
Mr. Counsel,
Uh,
we are saying that even we assume that you forwarded the memorandum by registered DD post, you did not send the documents. It is an admitted case. Para 13.
My lord, he made an appeal, my lord, before the DIG.
Even in the appeal, the same ground is taken. How does your appellate authority deal with it? Tell us.
He stated there in that we have received the memorandum.
Okay, that's all. Anything else to say? Do you have anything else to add?
My lord,
The direction is just to remand.
appeal
Yes,
at page 90, my lord.
yes. Read.
Page,
Yes.
my lord,
Page 90.
page, no, my lord, page 82, my lord.
Yes,
This is the appeal before the DIGP.
yes.
That he stated that and that the appellant is a married woman, para 3, my lord.
Hmm.
That the appellant is a married man who was ailing wife, who has ailing wife and having a minor children in his native village, and there is no other person to their family.
Come to
Look,
para 6 of the appeal.
that though he has a
Para 6 of the appeal, page 84. Para 6 of the appeal, page 84.
6, my lord.
Yes.
That the appellant begs to state that inquiry which has been conducted by the state force in a biased and arbitrary manner without following the due procedure of CRPF rules. And the appellant further state that he did not receive the document relied on for preparing the charge level against the appellant. For that reason, he could not take his proper defense before the authority. The appellant further state that before receiving
Yes.
an
Now-
inquiry report.
How has this argument been dealt with by the appellate authority? Tell us. Then come to para 7, page 6 of the appeal, page 87. Para 5, Roman 5. Roman 5, page 87.
Roman 5. For that, the inquiry officer and a disciplinary officer failed to consider that the whole proceeding was conducted one-sided against the appellant by not giving opportunity to verify the documents relying on framing of charge against the appellant without without granting opportunity of cross-examination, the witness produced against him. The inquiry officer as well as disciplinary authority does not serve the relevant documents relying on upon the petitioner preparing the article of charge against the appellant. As such, the order of dismissal from service of the appellant is bad in law and liable to be set aside.
Yes, what has the appellate authority said about it?
It is the observation. Huh? The
Yes,
having carefully my last para 5.
you have noted the response of the department in the paragraphs 4 onwards, right?
Yes, my lord.
So what does the authority say about this para? Pertinent assertion made in the grounds of appeal. How have they been dealt with? Tell us. Para 5, para 6. What does the appellate authority say?
Para?
Documents not supplied, no consideration. Nothing at all. Anything else to say?
But he admitted that he has not received the documents, but his brother received the documents. In his appeal.
Anything else to add?
My lord,
We are deciding the appeal finally. Anything else to say?
my lord,
That's all.
any another, but my lord, they have filed in a contempt.
You have argued. We'll decide. Don't worry.
Oh.
That's all.
Oh, my-
Okay. Yes, Mr. Chaudhary.
My lord, if your lordship will kindly come to page 84, madam,
Mm.
paragraph 5, last sentence. The appellant further states that he did not receive any memorandum and articles of charge from any competent authority.
Mm.
And for that reason, he could not submit any reply to the charge leveled against him. Now, my lord will kindly come to the learned single judge's order,
This DE was held ex parte,
my lord.
right? DE was held ex parte.
Yes,
Was any evidence recorded
regarding my lord.
for proving the charges? Was any evidence recorded?
No, my lord, what had happened, actually, after this charge sheet, they filed another affidavit before the learned single judge, where they, my lord, also took the stand that the notices were duly served. Then, my lord, the learned single judge, my lord, referred the matter to the forensic expert. To
Mr.
verify
Chaudhary,
the
we have put
signature.
this very simple question.
Yes,
Are we not audible?
no,
We put you a question whether the departmental inquiry was proceeded with by recording evidence of witnesses.
yes,
Read from the findings.
no, my lord,
Does
only finding learned single judge has arrived at is,
read the finding of the disciplinary authority, please.
Okay.
You are not probably getting the point.
I got it. My lord.
You got it? All right. That argument has not been raised. So that is why we are asking you.
Yes,
Where is the departmental, the report of the disciplinary authority?
no, record will be with them, my lord.
Report,
Oh, inquiry report.
inquiry report.
Yes,
Yes.
inquiry report to Gathi দিছে না আপনাদের?
Is it there on record?
In the writ petition, it was there, my lord. In the writ petition, it is page 42, 46.
Writ petition is with us.
Yes,
My lord, I have annexed the writ petition, whole writ petition.
Have you annexed the inquiry report? Page 42,
page 44, lord,
Yes,
may
my
come at the writ petition, my lord.
we are having it. 44.
The charge sheet and annexure 1, 2, 3, and 4 has been sent by the commandant to the accused constable so-and-so by speed post to his residential address. Departmental inquiry was started on so-and-so. In the investigation process, the accused constable Mukul Das did not appear. There is delay in
Mr.
recording.
Chaudhary, there is a concept in service law that even in ex parte departmental inquiry,
They are supposed to.
evidence
record
has to
evidence.
be recorded.
Yes,
So we are asking that question in that context.
Yes, my lord, this is the inquiry report, my lord. I
To read whether the evidence was recorded.
Evidence police. PW witnesses.
Evidence
Yes.
report, is it?
Witnesses is the my lord. Page 72.
Page
72, my lord. Witness now. It is at a. type copy.
72 of the memo of appeal.
Yes, my lord.
not the memo. It must be incorporated in the
In the
inquiry report.
The inquiry report is there, my lord, that we have annexed from page number, in the petition, page number,
Statements of the witnesses, yes. It refers to statements of witnesses.
page 40 onwards.
40 onwards. Where is the original report? Because type copy seems to be somewhat erroneous.
The articles of charge wise, my lord, the issue was dealt with.
Because though the officer says
Ah.
that evidence was recorded, but he doesn't refer to the
Yes,
names of the witnesses.
in the inquiry report.
You are having the report record? Are you having the record?
Original record. Original record, my lord, earlier, my lord, no, we have no. Right now, we have,
Statements of PW's evidence on records. Yes.
my lord,
And the proceedings were in Hindi, that is another problem, my lord.
But that is not a ground in your appeal.
My lord,
That is not a ground in your appeal.
no, it is a ground, my lord.
No.
I think so.
Read,
If your lordships will kindly.
Read,
take the
read.
Appeal memo, my lord.
read.
I think so.
Think is not the answer, Mr.
No, no,
Chaudhary.
I'm done.
To give a pertinent answer in this court.
Yes, yes.
yeah, my lord, this.
My lord will kindly come to page 55 of the petition, ground
We
number
want to
7.
see the inquiry report, Mr. Chaudhary. Where is
Just now,
the?
Lordship asks whether we have taken a ground.
Yes,
regarding
all
the
right.
Proceedings in Hindi. That
Okay,
is paragraph 7 of the memo of appeal, my lord. Page 55. That the appellant begs that the inquiry report has been given to the appellant on language of Hindi, which is not conversant with the appellant, or for the reason he could not submit his reply before the competent authority. This was already given.
Yes, witnesses are referred to force number so and so 745-174 GR Sinha. These witnesses were examined.
My lord, this honorable court, my lord, earlier by the order dated 6/6/2020, 2018, my lord, call for the original record.
Yes.
And thereafter, we filed an additional affidavit providing all documents. But he refused to accept his signature on the ID card.
Mr. Counsel, we are talking of, forget about the memorandum. What about the documents relied upon? You never sent it. That's your admission. That's
No,
the
my
chapter, end of the matter. Okay. The order is only of remand. What does the single judge say?
Remand.
Remand. Let there be
It will start
proper
from that
proceeding.
stage.
What is the problem? Let there be a proper proceeding.
Yes, yes.
Okay. That is an admission. They say that there was no need. It was your obligation. Give it the document. From that statement. With the consent of the.
My lord, in compliance of that order,
Yes.
if de novo proceeding is will be initiated, will be initiated, then the he may claim back.
He will definitely claim.
back
He will
wages.
definitely claim.
It will
wages.
to be under suspension, Lana, single judge has said.
He will definitely claim. What is wrong in it? It's your fault.
My lord,
Recover it from your officers who don't know how to conduct the inquiries.
he was engaged, he was appointed in a discipline course, my
So the disciplinary force can conduct the disciplinary inquiries without any discipline. That's it.
my lord, we have.
Okay, we'll deal with your arguments. Thank you. Anything else to say? with the consent of the learned counsel for the parties. Final arguments have been heard today itself. Judgment is reserved. All right.
Item number 7.
Please, my lord.
Yes, please.
My lord, the report of service on respondents 5 and 6 is awaited, my lord. Lordships may kindly fix it after vacation.
Await return of notices issued to the response numbers 5 and 6 for 3 weeks.
Most obliged.
Item number 8.
May please, your lordship.
Yes, please.
On the day before yesterday, my lord, your lordship wanted to know whether any appeal is pending against Purnima Hore, my lord. My lord, 3 appeals are pending before this honorable court, my lord.
Okay.
That is, writ appeal 156 of
Okay.
23.
In which matter?
In the case of Purnima Hore.
Purnima Hore.
My lord,
That's the main case.
main case. My lord.
So we'll connect your appeal with that appeal.
And only the, my lord, limited prayer before lordship that my lord, the order by which the petitioner was directed to contribute under the new pension scheme, that was under suspension by the honorable court, my lord, during the proceeding. That may be stayed, my lord. That order at page, my lord, 40,
40.
my lord.
The order. Under the new pension scheme,
Yes, my lord.
NPS.
Yes, my lord. Earlier, my lord, I was contributing under the old pension scheme. Now, my lord, by this order, my lord, I was directed to contribute under the new pension scheme.
Yes, Ms. Katniar, what do you say? Provisionally we'll stay
Yes, my lord.
without creating any equity in his favor.
Yes, my lord.
And counsel for the appellant states that appeal number
156 of 23, 157 of 23.
so and so have been filed
63 of 20.
by the appeals are by state.
My lord,
The appeals are by state or by the employees?
that has been admitted and
Appeals are by the state or the employees?
by the employees, my lord.
Employees, appeals have been, but there is no stay in those
There is
orders.
no stay, my lord.
Then you
But, my
can't,
lord, in this case, my lord, in this case, my lord, during the proceeding, my lord, there was a stay. So, my lord, I'm playing.
the same situation must have been there in that also. If you win, you will get it. What is the problem?
My lord, I'll
That will be virtually allowing your right appeal. If there is no stay in those appeals, then you can't get. That will be creating disparity.
my lord, but in the other case, my lord, this honorable court has already held that, my lord, these persons are not, they are not required to contribute under the new pension scheme. They will be covered by 69 rule, my lord.
In which case, these three judgments you have cited,
Yes, my lord.
whether the state has preferred any appeals in these?
No, my lord.
Ms. Katniar?
No, it's in our favor, madam.
No, there are 2 judgments wherein the court has held that they are entitled to benefit of old pension scheme.
Yes, madam. In that case, madam,
Yes,
we have not prepared any appeal, madam.
so then that judgment completely goes in their favor.
But madam, here, madam, the case is different, madam. In
What
case of-
difference? Same set of employees.
madam, there are total 4 kinds, different set of employee, madam. One was, my lord, regarding madam, they are drop teachers, other stipendiary teachers. In case of stipendiary teachers, court.
So, but
Hold
Mr.
it.
Katniar, the situation is that he was having a stay in the writ court.
madam,
So we'll provisionally stay that order.
My lord.
Heard
to that
and
effect, I
counsel
don't
for the
have any
appellant.
objection, madam.
This court is informed that similarly situated employees have preferred writ appeals which have been following writ appeals which have been admitted. And counsel for the appellant further points out that the appellant herein was getting the benefits of the old pension scheme before passing of the order dated 14/2/2017. The effect whereof was stayed by the learned single judge during pendency of the writ petition. In view of the submission noted above, it is hereby directed that effect and operation of the order dated 14/2/2017 shall remain provisionally stayed during the pendency of this writ appeal without creating any equities in favor of the appellant.
Right.
Connect with so and so.
Obliged.
Admit कर देना.
Item number 9.
Please, your lordship. My lord, the instruction that I have from my client is 75 lakhs being the outstanding. He, my lord,
You are supposed to bring a demand draft.
my lord, I understand. I am today, my lord, performing the role of a messenger. I am not even in the capacity of a counsel. What I have been instructed, I'll place it before your lordship.
Yes.
Thereafter, I'll leave it up to your lordship.
Yes.
My lord, the petitioner has prayed that he be allowed to pay 7.5 lakhs being 10% of the total amount within a week
No,
from today.
sorry,
And-
that doesn't work, sir.
And the rest within a month.
That doesn't work, Mr. Chakrabarti.
I'll leave it up to your lordship, my lord. I cannot embarrass. myself.
Dismiss as not being maintainable.
Deeply obliged.
Surface matter judgments क्या है ना? I'll dictate, don't worry.
Obliged. my lord.
Okay.
Item number 10.
My apologies, my lord. In this case, notice of motion was issued, my lord. I was directed to file an affidavit. But we waited for a registry to serve us with a copy, my lord, whereas we could have also collected a copy. Yesterday evening, my lord, I have collected a copy from my senior.
Let it go to the green bench, Mr. Manta.
And my
Yes,
lord,
my lord, there's a green bench.
my instruction is that, my lord, these two queries have already been closed, my lord.
List tomorrow before the green bench. Okay.
Can you give-
As prayed by Mr. Learned Counsel representing the Mr. Amicus Curiae, Ms. Manta
Yes, my lord.
and Mr. Goswami, AAG, Assam. Let the matter be listed before the green bench tomorrow.
Obliged.
Item number 11.
Environment bench. Prayer for change in date of birth. Pass over. You are there. File a suit, sir. Writ petition is not maintainable. They are disputed questions of facts.
No, my lord, what happened, my lord, while the policy of the.
We'll give you 10 Supreme Court judgments which say
National-
that the remedy is before a civil court.
Let me submit, what happened, the idea behind the setup of the National Open School for the dropouts, he was a dropout. When there was advertisement for the examination.
We are
he filled
not
up the form.
on the concept of NIOS, sir. We are on the aspect
Yes.
whether writ court will go into these disputed questions of facts.
My lord,
What is your correct date of birth?
humble submitted, it is
You
not
go,
written.
you have to file a suit for
I have filled
declaration.
up my form as 73.
You
But
have
they have
filed-
They have issued certificate, they have made 83. I left the school in 86, my lord. How
You
can they
have
my
to-
birth may be 83.
You have,
Their
filed-
only condition is that
okay,
I have not applied within the 3 years. But in fact, I have applied within 3 years of the pronouncement of the result.
okay, thank you. That's all.
Yes.
Dismiss, not maintainable. We'll leave you liberty, give your client liberty to file a civil suit. If he so desires.
Civil court.
Yes, civil court.
Item number 12.
My lord, on the last occasion, your lordship directed that. to
Yes,
produce that
the record is here.
My lord, the records that have been available.
Yes. Which is the notification?
My lord, there is no notification.
No notification. So the officers are at liberty to do whatever they like.
No, my lord. May
Yes, that is it.
May I
Precisely.
explain, my lord?
This is
in my-
nepotism on the face of the record.
In my
Yes.
affidavit, my lord, in my affidavit, which
Yes.
is a part of the memo of appeal, page 40, my lord. That has been explained, my lord. Page 40, para 7, my lord.
Yes,
Para 7, my lord.
yes.
Page 40.
The
That has-
person who secures 46 marks in the written examination,
Yes, my lord.
just in order to bring her in, you change the rule of the game.
No, my lord.
Plain and simple, yes.
No, my lord. In para 7, we have.
Yes, read para 7.
Yes,
Which
my
para? Which para?
That as regards.
Page
Page 40 of the appeal, my lord.
40.
Yes, my lord. It is in terms of the resolution of the committee, my lord.
page 40, para 7, my lord.
Yes.
That as regards the statements made in paragraph 7 of the petition, your deponent states that in the minutes of the meeting dated 24/4/2015, that has been annexed here with my lord, for selection contractual staff under RNTB TCP via advertisement dated 12/3/2015. The House decided to hold a screening test for the post of senior treatment supervisor, considering more than 1,500 applicants against 69 posts. Following the written test, it was decided to shortlist candidates for the viva voce at the ratio of 1:4 against each post for respective district based on the.
Where are those minutes?
Minutes, page 42, my lord. Annex RA,
Let's
my
see,
lord.
let's see.
In the minutes, my lord, that portion.
Just hold on, please.
Yes, my lord.
Hold on. Page 43,
42,
42. Let's read. Yes,
para 3, my lord.
come 43 you are reading now?
No,
43,
No, 42, my lord.
42 read.
Para 3, my lord.
Yes.
The House decided to hold a screening test for the post of senior treatment supervisor, considering more than 1,500 applicants against 69 posts. Following the written test, it was decided to shortlist candidates for the viva voce at the
Yes.
ratio of 1:4 against each post for respective districts based on the scores. In the event of tie for the last number, it was decided to include candidates scoring the same number.
Yes.
So in case of Dhemadi district, my lord, the concerned staff made a mistake. They initially selected candidate in 1:3.
Yes, yes.
Subsequently, on the basis of this resolution, the resolution was adopted prior to March, prior to that selection. So in para 7, subsequently, I have stated subsequently they have rectified that mistake. Because, my lord, following the written test, initially the merit list after the written examination of the Dhemadi district was prepared in the ratio of 1:3, which was done by the mistake of the staffs. Accordingly, against 2 vacancies, six vacancies were shortlisted for viva voce. However, subsequently the said merit list was modified in terms of the aforesaid minutes, and the list was prepared at the ratio of 1:4. And accordingly, against the 2 vacancies, 8 candidates were shortlisted for appearing the viva voce. In the said list, the name of the respondent number 7 appeared at serial number 8. Because initially it was by the mistake of the concerned staff, my lord. Because as per the minutes and resolution, it was to be 1:4, but they selected only 6 candidates for 2 posts, my lord. And secondly, my lord, these minutes have not been challenged by the petitioner, my lord.
That's right. That we
By
read.
2 grounds, only 2 grounds, my lord. One is that the minutes has not been challenged by the petitioner. And second ground is that, my lord, the number 1 selected candidate, Vidut Sharma, he has not been made a party.
No, he doesn't have any grievance against Vidut Sharma. You favored one candidate. That is the grievance.
Yes.
You just in order to bring her in, you change the ratio to 1:4.
No,
That is what the grievance.
no, 1:4 was adopted prior to the selection, my lord.
That we'll see just hold.
That was the
Where is the result of the viva voce? Where is the viva voce in sheet?
seats I have produced, my lord. It was 24/6.
Yes, so she gets 22. Just in order to somehow bring her in.
Yes.
The highest marks
My lord, there are
to any of the candidates.
3 members.
She is given highest marks amongst all candidates. What is so special about her? Tell us. Alpna Barua 21, Alpna Barua 22, Alpna Barua 22. What is so special about her? Apparent fraud. We are interfering in this. She is a party.
Yes, my lord.
She is not appeared.
In the read proceeding, she was on the last occasion.
Last occasion, someone was there, my lord.
We served copy on the last occasion, someone was there. my lord.
Who's there?
Answering about that?
D. Hussain.
Yes.
Number 7.
Yes.
Call Mr. D. Hussain. Call him. Pass over. Is she working? Or there was a stay? Stay order. Okay.
Item number 13.
Your Lordship, my lord.
Yes.
Last occasion is direction has been made to file an affidavit, my lord. I'm seeking some more time, my lord.
And only problem is lordship, already my lord, recruitment.
10 years.
Lordship. Advertisement is
Some more
issued on 6/10/2022.
Come on, 17th.
For filling up 51 vacancies.
17th, file the affidavit.
One may be kept vacant out of 51 lordship.
Have they advertised?
Yes, Lord, one, on 6/10, my lord, advertisement has been issued, my lord, for issue.
That,
for
17th, my lord.
51
Let it
existing
be on
vacancies.
17th,
lordship.
my lord. We file an affidavit.
where is the advertisement? You are having it?
Advertisement, not my lord, just now, my lord, soft copy is my lord provided to me, lordship. My lord, it was issued on 6/10/2000, my lord, the 51 existing vacancies going to be filled up, lordship.
All right, come day after tomorrow.
My lord,
Come out day after tomorrow.
only difficulty in this case, my lord, we have received some instruction, but that instruction is not in conformity of the order passed by this court, my lord.
So,
Complete your instructions day after
Kindly
tomorrow.
teach on 17, there is no.
Friday,
My lord, Monday, my lord.
Friday.
My lord, I have written.
All right, then stay.
My lord,
Then we'll stay on recruitment.
my lord, Friday.
Is it okay?
My
Are you happy? We will record.
Lordship, kindly fiction, and if not possible, my lord, Friday.
yes, lordship, Monday, lordship, my lord, subject to my lord.
All right, Monday.
Assurance given by lord.
Well, then Mr. Sharma
All
pays
right.
for further opportunity of, short opportunity to file the affidavit in terms of so and so. List, order date so and so, list on 16th.
Obliged.
Item number 14.
But in this matter, I had a meeting with the officers on Monday, Malad.
Hmm.
But some difficulty on their part is there, Malad, because the honorable court order is there, Malad, discussing the writ petition as well as the no approval is there, and the work is of.
All your officers,
I have suggested them, Malad, I have suggested them.
they have extracted the work from him. Often it happens, the contractors are asked
Now,
that you finish the work, we'll ensure payment is done. It's not nothing new.
Malad, that's true.
If you apply those strict yardsticks, no contract, we'll provide in this order that henceforth, no contractor will perform work beyond what is his.
Malad, I have
Not
suggested-
even an inch.
I have suggested them to verify the records, Malad, whatever is available, because the officers at that point of time, they are no longer there. But I have.
He would not do a excess work out of his sweet will, you can understand.
No, but now if we want to say something, we have to have some basis for that, Malad. The
So
officers.
that is why we have given the opportunity
Correct,
to you.
Correct, Malad. I have called the officers. I have a discussion with them.
Mr.
Malad.
Nath, senior government advocate, Mr. Nath
Lordship.
appears and submits that further short opportunity
Lordship.
is maybe given. He is already in talks with the officers
Lordship.
and short opportunity is required to complete the instructions regarding the claim of payment towards work done raised by the petitioner in this proceeding,
Lordship.
appellant in this proceeding.
Malad.
Re-notify on 8th November.
Lordship. By that time, I'll finish.
Item number 15 and 16.
Yes.
Here, Malad, in the other appeal, the appellant has filed the affidavit, Malad, bringing some documents, Malad. I have sought for the instructions in that.
We had asked for the passport. What has happened?
That passport.
My lord, I filed my affidavit with regard to them
When?
on the last occasion. Thereafter, the reply was asked to be filed against
Lord,
my affidavit.
That.
No. On last occasion, we read your affidavit and said that the passport is missing. That is what the order 25/8 says.
My lord. I have given my passport, my lord. at
Where?
163. page number.
163. Oh, you already filed it.
Yes, my lord.
Okay.
already filed it.
Yes, Ms. Nath, the passport is here.
The passport, he said, now this is issued subsequently, Malad.
This is subsequent passport.
Yes,
Yes,
passport.
we need it for that period.
Yes, ma'am. For that period, my lord, I have already submitted that. My lord may look in my affidavit once.
Yes.
My lord, at annexure 2, my lord,
Hmm.
it is a passport which are issued on Sydney, my lord.
On?
In Sydney, my lord, on 2/6/2000 to
Hmm.
1/6/2010, my lord.
Hmm.
Thereafter, my lord, I have also given my visa as per the order.
Okay.
That is at 160.
But there is no endorsement on this visa. What is your period of stay and everything?
My lord, it's there, my lord. It's there my lord, it's written
the granted 14 June multiple travel must not arrive after 14 June 2005, holding permitted FC remain in Australia. At bottom, my lord. Even I have stated that in my submission also, madam. What's been written there?
Ms. Nath, you have not completed what do you say about this?
But I have sent the copy to the authority, my lord. And because in the meantime, whatever document that he has placed before the authority, because these are coming up before the honorable court for the first time.
Yes, you're right.
I have sought the response from them. my
You
lord.
want to file a response?
Lordship.
Ms. Nath submits that some more time is needed to file a response / affidavit, additional affidavit in reference to the amendments made in the additional affidavit of the appellant filed on 22/8/2023. 4 weeks time is granted for doing the needful.
My lord, can we spot it, my lord, because they're already coming with the promotions.
Not possible, not possible. He had enjoyed his stint in Australia. He has to face the music.
Item number 17.
My lord, in this case, Public Service Commission said that the notification which we annexed in our additional affidavit is wrong. So they wanted to produce the correct one.
Yes, come this, bring this president. What is your stand, Mr. Datta?
Lordship, that annexure which he had produced by the learned pen, Lordship, is not the correct copy, Lordship. This is the
At the pink flag?
pink flag, Lordship.
Okay.
But it the
Yes, so 70 has been made it to 80.
80, Lordship. Moreover, Lordship, the next page, Lordship, is the original which they have annexed, Lordship. In bottom, Lordship will find page number 1 of 4. Lordship, in the affidavit, Lordship.
Yes. 1 of 4.
1 of 4 in the affidavit, Lordship. They are annexed, Lordship. But in our resolution, it is only 3 pages, Lordship.
3 pages, yes.
But the content,
Content is different.
totally different, my lord.
70 is not there, 80 is there. The percentage is 80, not 70.
Even 80 is attractive, my lord, because he has given 90%.
And Lordship, I have
90%.
Lordship, instruction also, Lordship. I have placed instruction in this regard, Lordship. And that resolution is on another context, in not deal with that present interview, which my learned.
Naturally, it is not connection with this
Lordship, let me
interview.
complete. Lordship.
Generally.
Anyway, Lordship, they have produced a document and it is shown from the record, Lordship. Lordship can verify from the additional.
Yes, yes,
Where from it got, Lordship. It is not the administration of hampering the admission of the Lordship.
Your client will have to face
No, my lord.
the consequences of
No,
filing
We'll verify it.
a
Lordship-
fraudulent document,
No, no.
forged
Lordship-
document.
Lordship will kindly come.
Plain
to
and simple.
Page 153 for a moment, my lord, of
Yes.
the memo of appeal.
Now, first we want to settle this issue.
Yes.
So this is a fabricated document.
Let them file an affidavit, we'll reply, my lord.
The original is here, we are noted.
Then I
You are noting.
must have a look, my lord.
All right, you
Definitely.
have a look.
Or let
Let
my
him see.
learned friend give a Xerox copy of it.
No,
Let him
Lordship.
see. Let him see. Give a copy.
No.
All right, we'll record your statement
Lordship.
and we'll take note of this fact. In
My lord, the
furtherance,
difference of mark was 0.06.
that's not the question presently, Mr. Chaudhary. If a litigant in this court dares to
Yes.
file a fabricated document,
Ah.
whether it be entitled to any kind of relief.
Rajiv
Lordship,
Bola Singh hai?
he is going to be a principal of a government college.
Yes, yes.
He is the integrated conduct, Lordship.
Learned, Standing Counsel, Ms. Datta, has produced the original record from the commission pertaining to the meeting dated 18/5/2022. A perusal of the minutes would reveal that at item number 1, the percentage of marks which is indicated for the purpose of recording reason is more than 80%. The appellant herein has produced a copy, photostat copy on affidavit at page number 175 within bracket annexure 1, wherein this figure is 70%. Apparently thus, the appellant has filed a false document. When counsel Ms. Chaudhary, on the request of Ms. Chaudhary, let a copy of the original minutes be provided to him today itself, photostat copy. He prays for and is granted 3 weeks time to complete his instructions.
My lord, only difference is 80%.
Whatever, sir,
Yes, other
whatever,
line by line it is same.
whatever
Yes.
the document which you have produced is not the correct document, and the appellant will face the consequences. We are sure of it. Litigant can't be permitted to take the
No, my
court
lord.
for a ride.
Certainly,
It's
my
too
lord.
serious.
Litigant will not
Will-
do.
On next date, this court shall consider initiating proceedings under section 340 CRPC against the appellant. Make this a part of the order.
My lord, that lordship can
Has to be
defer-
done, sir.
Lordship will defer.
No, we are recording it right now.
Defer it to the next date.
We'll
my lord.
consider. That's all we have recorded.
That observation may be.
Yes, it will remain. It will remain.
Item number 18.
My lord, the matter relates to award of a contract.
Hmm.
Now, what had happened, my lord, initially the private respondent was, my lord, found to be technically not responsive.
Hmm.
Now, subsequently, after the last date of receiving tender, my lord,
Hmm.
the private respondent was made responsive.
Hmm.
Now, I'll just place it, my lord, the consideration. Only thing is, my lord, employees provident fund registration was not given. Yes. Now, my lord will kindly come to page number 283, my lord.
The private respondent is represented.
Yes.
Private respondent is not represented, my lord. No notice was served.
Notice has not been served.
In the writ proceeding, my lord, notice was served that didn't appear. So far as the present proceeding is concerned, my lord, no notice has been served to the private.
Has not been issued or not been served.
Notice not issued, my lord.
Not issued. That seems to be an omission on part of the court. All right, issue notice. Ms. Tiwari, Senior Counsel Ms. Tiwari puts in appearance on behalf of has already put in appearance in caveat on behalf of the response numbers 1 to 5. The steps for service
2 to 5.
2 to 5.
Because
Union of India
is a very.
is a formal party. Service upon the Union of India be effected by providing copy to the PSGI, Mr. RKD Chaudhary. Let process steps of service on the respondent number 6 be taken within 3 days, whereafter process be issued. Notices may be forwarded by ordinary process and so also by email. Ms. Chaudhary, you can get the notices served by email also.
My lord.
For one, take the notes, go away. Yes.
Supplementary list for orders, item 24.
So again, leave to appeal.
Lordship, this is regarding admission in MBBS, my lord, first year, my lord.
Hmm.
Here, my lord, the appel in my lord, all along appeared.
Yes.
My lord, here this appel in my lord, all along appeared in the counseling, my lord, as OBC NCL, my lord. And that category, my lord, it has to be registered in the earlier occasion from 6 March to 6 April, my lord. That registration was continued, my lord. Then, my lord,
Registration with whom?
registration and for apply for NEET exam, my lord.
Yes, okay.
And my lord, already when he has been selected and his name has come in the state rank list, my lord. That's the respondent number 5, all along, though she was belonged to OBC, but she did not apply under the OBC category, my lord, OBC NCL category.
Okay.
all along she applied under the unreserved category. Then, my lord, after fourth round, all along she was shown as general category. I was shown as
OBC NCL. Okay.
Then, my lord, on 28th of September, my lord, 28th of September, my name has been reflected as the selected candidate, my lord.
Okay.
Lordship will come at page 92, Lordship.
92.
92, my lord. Admission notice. My lord, here,
Just
stay round.
give us a moment.
After 3 round, it has been 4th round, my lord.
Give us a moment, sir. Yes. Yes.
Then Lordship will find the respondents number 5 as page 93, Lordship. Sayana Kashyap. She was shown as general, my lord. Top of the.
Yes. Yes.
Then
General.
Lordship will find next 94, my lord, in the 4th, Anurag Chetri, my lord.
Yes. OBC, MOBC NCL.
And my lord, his name has been shown in OBC NCL at Kokrajhar Medical College. Kokrajhar, my
That was alerted to him.
Yes.
Yes. Then
Now, surprisingly, my lord, this respondent number 5 came before this honorable court.
okay.
Lordship will find at page 95. She's saying that she has not got the NCL certificate from the deputy commissioner, which has been rejected on 18th of September. So the honorable court.
What was the last date for submission of the forms?
That was 6th of April, my lord.
6th April.
Lordship.
So on that date, she was not having an NCL certificate.
No. And ultimately, this honorable court was pleased to direct at page para 7, Lordship.
Just a minute. Para
7 of the
order.
Court's order.
Yes.
98 page, my lord. The daughter of the petitioner is also directed to immediately approach the director of medical education for doing the necessary formalities. The director of medical education to take note that there is already a declaration by the court as regards the entitlement of the daughter of the petitioner for non-creamy layer certificate. And therefore, even if there is a delay on part of the deputy commissioner to issue certificate, the same shall not be a reason not to give admission to the daughter of the petitioner, provided she is entitled on merit in all other aspects. The writ petition disposal, let a copy of this order be furnished so and so. Now, Lordship, on the basis of this honorable court's order, the category totally has been changed from general to OBC to her. My Lordship will find at page 29, my lord.
It was not changed as he is saying. He's
Forget about change or everything.
Lordship.
The fact remains that when filing the application, the candidate respondent number 5 did not apply under the NCL.
No, Lordship.
Is it a fact?
It's not, it's a half correct, half not correct.
Okay, then how it is half
Yes,
correct?
when she applied for NEET in the month of April, she
Who?
said
Who?
the writ petitioner.
No, we are not asking about the writ petitioner. We are asking about the respondent.
Respondent.
Yes.
Yes,
Under what category did she apply?
she applied as a general in the NEET. And before the counseling on 1st of July, there was a notification. We have just for it, maybe at the printout, maybe before this honorable court. There is a notification of 1st July where all the candidates who want to change their category, they were permitted to do so.
That can't be done. That's a contrary to the Supreme Court judgment. This recent judgment of 9th October by the name just
9th October, Lordship, but our notification was of 1st of July.
even before that, there is a judgment Sakshi Ada. If the candidate has applied under general category, the candidate cannot be permitted to change the category.
But that is
to
a
NCL.
subsequent judgment, Lordship.
No, earlier also. We'll give you the judgment.
Lordship.
Take out a judgment by the name of Sakshi Ada. 18th May 23.
Because we issued the notification because from various earlier experiences, the candidates who did not get the certificate on
Can't
time.
be done, Mr. AG.
Yes, then we will not.
Whatever the application is there, it has to be treated in the same category. You read this judgment.
Now when
Take out a judgment, this Sakshi Ada is decided on 23rd May 18. You got it? No, this is a different thing. You take out this judgment. 23rd May 18, Sakshi Ada. We'll pass it over. You have a look at this judgment. This is not permissible. And 9th October Supreme Court has categorically laid down.
Absolutely,
That-
Lordship. We have no quarrel on the proposition of this honorable court as well as the Supreme Court.
Yes,
We do not want to do anything which is contrary to the law
yes.
or the settled position of law.
Mm.
So we issued this notification on 1st July 2023.
Yes,
May I read it, Lordship?
yes.
Clause 1. Candidates whose name appeared in the provisional merit list
Mm.
and want to change their category
Mm.
can now apply in a prescribed format which will be available in the official website
Ms.
of the
Saikia,
director.
Ms. Saikia, there is a
This may be wrong.
patent flaw in this for
No
the
doubt,
reason.
Lordship, it
Just,
may-
just,
but
hold on.
it has.
Even if you allow, the issue is that the category of NCL will apply from the date on which the certificate is issued. It can't relate back. So there is a
The admission was subsequent, Lordship.
date of filing application, sir, that is relevant.
The
is
date of filing application in the state is after this. There are two types of admission.
Yes.
One is regarding appearing in the NEET,
Mm.
NEET. And thereafter a subsequent admission notice is issued by the respective states.
Mm.
In our state also, we issued that notification
Yes.
after month later in the month of.
All right,
July.
let us know. What was the category of this private respondent before she applied? Was she ever?
No, she was
NCL
general. She was general. We-
She can't be treated to an NCL candidate. Can't be.
That is
This
what
is
we
too
have
much,
also
Mr.
done then. They came.
This
to
is
put out
just too much, Ms. Saikia, that you are now giving a freebie to the
a-
candidates.
No,
You
there's
get
a
your
direction of
certificate.
the court. We have not done it on our own. There's a-
1st July is not the direction of the court.
No, 1st July, we have issued it
Yes. So
because
this is totally illegal.
nobody has challenged it and we gave a fair opportunity to everybody.
We are not at all
No,
satisfied.
It has to be tested, Lordship. It
Where,
has to be-
where?
Somebody will have to test it that nobody
We'll
can
test
change.
it right now. No? We'll test it right now.
Then we will file an affidavit to this.
So do this, do that.
Lordship.
Yes, all right,
Yes.
do it.
Somebody will have to test it,
We'll
Lordship.
test it right now on the touchstone of the Supreme Court judgments.
No difficulty.
Let's see.
Will,
Let's,
Lordship.
yes, all right.
Lordship will kindly give us 1 week's time to file the affidavit.
Yes, all right. In the meantime, we'll stay the direction to provide the seat to that respondent.
I think it has been already given, Lordship.
But she had also been selected. You turned her out of the selected list.
Whatever order Lordship directs,
That's
if it is
really-
implementable, Lordship will do it.
We'll make it and we'll make it sure that it is
No,
implemented.
somebody will
Don't
have to
do-
go out.
Yes, has to. She has been sent out for no fault of hers.
If Lordship directs, we have nobody to protect.
But this really, we failed to understand this notification, Mr. Saikia. This changing the rules of the games after the
The
process has
games-
started.
There are two types of games, Lordship.
Yes,
One
yes,
game was appearing in NEET, that is a qualifying examination.
yes,
The other one is regarding admission.
Mm.
There are two different sets.
yes.
There are the division, Lordship. There are two separate events.
Okay.
The first event is regarding appearing in the admission for appearing in the NEET.
Hmm.
From
Can we have a look at your NCL certificate? Any NCL certificate on record?
It is not there.
Can you provide a format of the NCL certificate?
Lordship, yes, Lordship.
Do you have anything?
In other case, we have. Lordship.
Let's see that. Let's see that.
And we'll also find the background why this notification was issued.
Sure, sure. Yes. No, this is not the judgment. This is the name. Where's the final judgment? 75 pages. Oh, really leave it right now.
Thank you, sir.
Okay, let us see the facts of the present case for the moment. Assuming that this circular is there, let us see the facts of the present case.
Now Lordship will find,
Hmm.
Lordship will find at page 61, Lordship.
Mhm.
This is the revised provisional Assam state merit list of NEET undergraduate 2023.
61.
At page 61, Lordship, 1133 serial number,
Just a moment.
state rank, my lord.
1133, yes.
State rank, my lord. The Sayona Kashyap,
Hmm.
female.
Hmm.
She was general.
Yes.
Then in Assam quota, my lord.
Hmm.
Now Lordship will find next page 62,
Hmm.
2676, my lord. In state rank, my lord.
Yes. Anurag Chetri.
Anurag Chetri. He was
OBC
made
NCL.
OBC NCL, my lord.
Yes.
And Lordship will find next annexed the first round admission, my lord. First round at page 63. I'm going to show Lordship's next 64 Lordship. The select list.
64.
64.
Yes. That you showed us, no?
4/8/2000. No.
4/8.
4/8/2000.
Just, yes. Anurag Chetri, OBC NCL,
Yes.
but he has not been allotted any college.
Yes, you are NCL and next, my lord, 65 at page 65, 4, serial number 4.
Yes.
Saina Kashyap,
Yes,
unreserved.
unreserved.
Yes. Then another date, my lord, that is on 9/3/9, my lord. That is page 66.
Yes.
Lordship will find the select list 3/9/6/23 at page 67.
Yes.
The respondent number 5.
General.
Yes, she was general. At page 65, serial number 930, Lordship.
Yes.
930. She was shown as general, madam.
Yes.
All along. Madam. That is 39. And in 1468 serial number, the Anurag Chetri was shown as OBC NCL. And the third round online counseling, that is notification was issued on 18/9/2023. Then Lordship will find at page 70
General.
the select list, the serial number of the
884.
884.
Yes.
She was as the general category, madam. And where is the 71?
Yes.
71.
Anurag Chetri
last.
was all along being considered as a OBC NCL candidate.
OBC NCL. And lastly, the fourth round, my lord, where I have been selected, 28/9/23, my lord, this admission notice.
Okay, now let us know, when did she apply for change of category?
She applied, my lord, as per the honorable court's order. Lordship will.
Where is
find-
that? Where is that? Let us see.
This Lordship will find at page 98, Lordship,
90.
para 6. It has been stated. In view of the above, the
No, no,
rejection.
we want to know what is the date of our
Yes,
application.
18/9.
No, that is the rejection. What is the date of application?
That part I do not know, my lord. Only rejection part I know.
She must have said so in writ petition.
And she approached this honorable court on 29th,
We want to ask you, Mr. Chetri,
Lordship.
when did she apply? Where is the writ petition? Let's read the writ petition.
Her writ petition, my lord,
Writ petition was filed by the candidate, that one.
the candidate's mother, my lord.
Yes. Let's read the writ petition.
Yes.
Page.
No, the order, Lordship,
You did not file the writ petition.
no, I did not find there.
You are not a party.
I was not a party.
Ms. Saikia, you are having a copy of the writ petition. Sayona Das must be having. Let's see that writ petition. The simple answer to the issue without going into the niceties of your.
I think it is annexed, Lordship.
No, it would not be.
Anurag-
He was not a party. He was not a party. This unhappy situation which has been created and rather a mess, Ms. Saikia. How can we approve that so many candidates have been sent out without hearing? Single judges orders have been passed to the adversity of candidates without giving them an opportunity of hearing.
That is a fundamental, even the national
Really?
NMC should be mid party.
That's really, we really fail to understand this. It's shocking to our conscience.
This is petition concern.
Can you ask your associate to bring a copy of the writ petition?
Yes,
We'll pass it.
5730.
Yes, we'll pass it over. We want to read the pleadings of that writ petition.
A little bit, we'll get it from the chamber, Lordship.
Do that, please, Lord. Or you get the file right now. When are the matters listed before single bench?
It was, the judgment was delivered on 29/9.
Is it an interim order or final order?
Final order.
It's a final.
When
order.
the writ petition has been decided,
Disposed of.
get the copy immediately. Get the file. Really. You just wait for a while, Mr. Chetri. This is not the only one. So many matters candidates have been sent out without hearing.
I had a discussion regarding this yesterday, Lordship.
Really shocking. Absolutely. Already we can do it as per our
Problem
wisdom.
is that whoever comes to the court, their faces are seen. Those persons who are behind the court.
No, that was apparent.
In most of the cases, not only this
It
medical
was,
case.
it was an apparent outcome of this order.
In most of the employment, the service matters, that is happening. Whoever comes to the court always have the leaning toward them. Who are not before the court, their plight is never considered.
That's really.
This is a very general statement I am making
Why
from my
don't you,
experience.
why don't you take this in a pleading? You normally do it in our court.
Yes, I do take.
Then
take.
why don't you ask your associates to take these pleadings in the single benches?
I-
It has to be there.
Yes,
The candidates likely to be affected not being made a party. Writ petition can't be entertained or what to say of being allowed.
Whoever will be adversely affected, they should be made.
Has,
But
has
that's
to
the
be.
cardinal
It's a cardinal
principle of
principle.
natural justice.
Really, this is really painful, we'll say.
We'll get the petition, Lordship.
All right. And this one judgment of 9th October, Supreme Court judgment
Lordship.
by Honorable Justice J.K. Maheshwari. It's, the precise judgment is candidate cannot claim EWS quota if certificates are not uploaded in the prescribed format before the cutoff date.
Lordship. The format is, we have received the format. Lord.
Before the cutoff date, it has to be uploaded. If that's not done, that's not done. That's
True, Lordship.
Yes. All right, you just get the writ petition, then we'll see. Pass over. We'll get the record because the file is decided. We'll get the record from the office.
Lordship. And regarding this first July's notification,
Hmm.
I'll get the file. What was the rationale?
No, all right. Even beyond that,
Now
what we
the
are-
judgment has come.
what we want to see is when did she file? Even as per your notification, the last date was 7th July for filing the application for change.
Yes, yes.
Whether she applied before that.
She applied.
Doesn't
as-
seem. Because all along till September, her category is shown as general. So maybe this matter can be decided without going into the niceties of your circular. Maybe. That's why we
Lord.
want to see the writ petition.
Lordship.
Item 25,
Obliged.
I has been listed seeking leave of this honorable court to file an appeal, my lord. I am the third party, my lord. I was not party respondent.
Why are you affected by the order?
My lord, page 5, 32 of the memo of appeal, my lord.
Appeal then. Appeal.
Matter relates to selection and appointment of grade LDA, my lord, in a particular high school.
Yes.
And I participated in the selection process. I secured second position and private respondent secured first position.
Okay.
But the selection committee as well as the headmaster has given undue benefit to the private respondent. As a
So
result,
you yourself say that he was first.
he was first.
Then
Thereafter, my lord, the inspector of school on my tier, I approached this honorable court and this honorable court directed that since the inspector of school has not yet approved.
there were two different reports.
Yes, my lord.
The second report was accepted.
My lord, by the honorable court, my lord, page 32, that order was passed by the land.
All right.
Yes, by
Uh,
the
I yet seeking leave to file an appeal, accepted, having heard and considered the submissions advanced by learned counsel for the applicant, and after considering the grounds set out in the interlocutory application, seeking filed by the applicant, seeking leave to file an appeal against the judgment and order dated 26/9/23 passed by the learned single judge in writ petition number 7720/2018, wherein, the applicant was not impleaded as a party, we deem it fit and proper to permit the applicant to file an appeal against the said order. Thus, the IA is allowed. The registry shall register the connected writ appeal and place the same for admission
urgent matter, my lord, tomorrow.
after in the next week.
Yes.
Nothing urgent about in this matter.
My lord, in the meantime, the appointment may be given, my lord, to the private respondent.
He was otherwise also first in merit, gentlemen.
But there are.
You will not get a stay, we are sure.
There are large scale illegalities. ma'am.
I will see. Don't worry. The entire process can be set aside if required. Next week. List on
Item number
Monday, kar do. List on Monday for admission.
Tuesday, my lord.
Tuesday.
Yes.
Okay.
Item 26.
If I have received the records,
Mhm.
I have made a small index.
Let's see, let's see.
The record will be this one. Copy दियो करो. नहीं दे फोटो दे.
Yes, yes.
Lordship. If Lordship is pleased to look at the index, Lordship.
Yes.
Charge sheet in case number 49 of 2013 under 294, 323. Charge sheet FIR number so and so 294, 354, 509. Then 2000 FIR against and Nirav 105. Then memorandum by Diffu Government College Students Union flag 4. Dr. Nirav Kumar Sharma was placed under suspension. He came before this honorable court by the council. He was put. Enquiry report of joint secretary. So application of the petitioner for inspection of documents, so-called notice, complaint to vice chair, memorandum, memorandum of teaching and non-teaching staff of college. FIR by Nirav Sharma. He also filed one FIR.
Yeah.
Then appeal filed by GC Teachers Association. Release order of Nirav Sharma 2014. Memorandum.
Release order means?
Lordship release order.
He
was released.
He was released also by the council once. That we approached the court.
So he did not want council to take action. Then
the council cannot do it.
Yes, Lordship. That is a point of debatable.
That's the debatable issue.
Then enquiry report of Deputy Secretary 2020. Then financial irregularities, Lordship. I found amazed to find out one very important.
That AG's report, no?
AG's report.
Where is that?
It
Flag
is in
16.
flag 16.
That's what we are trying to find out.
AG's report. Fund was given for purchasing a vehicle by the principal. He registered the vehicle in his name for 4 years. Then when it was found out in 2018, he changed it, the registration name.
That's precisely what we are trying to search. Not able to. Okay, it's here. Yes.
Vehicle. Regarding vehicle. Regarding vehicle. And 40% of the teaching staffs are SMEs, Lordship. They are not Kirby.
Okay.
The complaints, FIRs are lost by SMEs people. He's trying to draw a line that he is SMEs, that is why the Kirby people are against him. That is not correct at all.
If that had been correct, Mr. Saikia would not have accepted a brief against him.
Lord.
Just on the lighter vein.
Lord. But the students and the college should function in proper atmosphere.
Not going to work well if your client continues there.
No, Lordship, Lordship may kindly give me some moments.
Yeah, we will give you ample time.
The Lordship, kindly give me some moments. Lordship, as far as this financial irregularities by report by Accountant General, there is a new fact, Lordship, which I have come to know today.
We have called for the record.
There was, I have come to know today only. There was nothing, no aversion, nowhere it has been mentioned earlier. So Lordship may kindly see that index, Lordship, for a moment, Lordship.
Yes.
Kindly see the index. The index, Lordship, the incidents, Lordship can see, Lordship. Incidents, all these incidents, Lordship, relates to 2014, prior to 2014. Now, Lordship, for a moment, Lordship, I will take your Lordship to, take your lordship to the repeat of that memo of appeal, lordship. How, lordship, the sequences have happened, lordship. All these incidents are 2014, lordship, I pointed out. Now we are in 2023. That attachment order was passed in 2021. Your lordship. Now, in between, lordship, 7 years have passed. There was no incident about, nothing has been reported, which has given a cause of action to them to attach new.
Okay.
Now, lordship, the sequence of events, lordship, will kindly come to.
This, Ms. Sakia,
Lordship.
this inquiry report of Deputy Secretary, flag 15, we don't find it anywhere. What is that inquiry report about?
That also we were not aware also.
We just want to have a look at it.
We were not aware of this.
Not there. Give it.
All these documents reached a little bit ago, Lord, so I could not go through all the papers.
Because they are not a part of the writ proceedings, that's why. The new things.
These materials were, lordship, not placed before the single bench, though they have agreed to bring those on record. Those are not before the single judge, lordship. As far as affidavit is concerned, lordship, some allegations are there, and we have replied to the affidavits. The replies are there, lordship. If these materials were against me, lordship, some opportunities would have been given to me.
This inquiry report perhaps contains all the allegations, Ms. Sakia. That's right. Or only regarding the vehicle. You have not registered any inquiry on this report. This was an irregularity.
In every stage, Lordship, we had to face the interim orders of the Honorable Court.
We'll definitely come to the court, lordship, if there is some illegal.
There are
evidence.
series of litigations, Lordship, where the council was restrained.
Just consider this. What we can do is
No, lordship.
just
Sure.
we give out a proposal that these dates sequence of events what you have stated. After 2014, there is nothing. What we suggest is that as an interim measure, we allow him to join and work for 3 months.
He's working, lordship, already.
He has rejoined.
He has already joined and he's working, lordship, because
So,
suspension was.
under observation by the principal secretary, if there is any incident in these 3 months, then we can take and we can.
Lordship, from 2014 onwards, most of the time he was not working.
No.
Number one.
That's
Number
nothing on
two,
the
from
record.
2000.
There's nothing on
What
record.
else, Lordship?
Not looking at the the principal secretary's letter to the government. The latest one, 2023.
Let's see, let's see.
Wrote to the government. In July 2020, August 2020, principal secretary.
Okay.
Yes, I can. Yes, I
It's publicly
by council or by the state.
You want to have a look at this letter? This is self-speaking.
The lordship, that is the council, lordship. The principal
Whatever.
secretary of the
The
council.
facts are there. This is based on certain hard facts. If you want to have a look at it, we'll hear you tomorrow then. give a copy of this letter to him.
Lordship.
It's all self-explanatory. The main part of this, the main contents of this letter regarding the failure to get the NAC tradition, that is very serious.
From 2014
That,
onwards.
Lordship, that we have replied to, Lordship.
You have a look at this letter. We'll hear you tomorrow. Ms. Sakia has produced the original record for the court's perusal with the assistance of Standing Counsel, the KAC. In the record, a part of the record is constituted by a letter dated 22nd August 23, forwarded by the Principal Secretary to the KAC, DIFU, to Additional Secretary to the Government of Assam Higher Education Department. Copy of the said letter be provided to Mr. Kalita.
So Lordship, they can bring this, all these things on record.
Let we are simply having a look at the letter, nothing beyond that. List tomorrow.
Deeply obliged, Lord.
Play the original record of this.
Item number 27 and 28.
That medical admission case, my in my case, my lord, they have not filed any affidavit and my lord.
28, my lord.
We have filed one affidavit.
Yes. We have filed the affidavit, Lordship, enclosing the report, inquiry report also.
Item 29.
In item 29, and same will cover everybody's case, Lordship.
Give a copy to everyone.
Yes, Lordship. We'll right now.
My lord, 29, the report has been furnished today, my lord. So before I take your lordship to the report, my lord, just a quick backdrop, my lord. My lord, will kindly come to the impugn order, my lord.
29, yes.
Directly, my lord, at page 33
Of this.
of the IA. My lord, will take up the IA.
IA.
All the documents are there in the IA, my lord.
IA then. 29.
Page 33, my lord. Paragraph 16.
Oh, no, ये कहाँ है इसमें? IA in which case?
IA in item number 29, 28, my lord.
Rani Nayak.
29, my lord. I'm so sorry. It's Smita Kumari Mahato.
Smita Kumari Mahato.
Smita Kumari Mahato. Page 33. 33.
There is no page 23 in this.
Page 33, my lord.
33.
33.
You are reading from the affidavit.
From the IA, my lord, for seeking leave, my lord. There is an IA.
Oh, that leave application we have allowed yesterday.
Yes, my lord.
This is implement that yesterday's application.
That I found IA essay for leave.
That we allowed yesterday.
3048. 3048.
Okay. What are you referring to?
Page 33, my lords. Paragraph 16. That is the impugn order passed by the Honorable Single Judge. From such point of view, certificate that the petitioner Chani Bhuya relies upon would have to be accepted as authentic certificate in as much as it is issued from the office of the Deputy Commissioner Nogao and it is supported by some further certificate by the so-and-so. So insofar as the certificates are concerned, the Honorable Single Judge himself has admitted that they are authentic and they are all right. My lordship may next come to paragraph 20, page 40, paragraph 29. This is the bone of contention, my lord. Page 40, 29. The requirement of a factual determination as to any of the predecessors or forefathers of the applicant was working as a tea garden laborer would necessarily involve the requirement of making factual verification as to who was the predecessors, forefathers, and in which tea garden and for which period the person concerned had worked as a tea garden laborer. Such information can only be obtained from the tea garden concerned where the person had claimed to have worked and not on the basis of any certificate issued by any one authority or the other without any factual determination. Now, my lords, the Honorable Single Judge, in my humble opinion, my lords, he devises a new, my lords, a rule which is dehors the rules governing the admission and also the judgment rendered in Kumari Madhuri Pati. Next, my lords, paragraph 33. Thereafter, it is referred to the committee. Page 41, paragraph 33. From such point of view, we refer the matter to the state level caste scrutiny committee to give an opportunity to all such applicants who are
Just, Mr. Mahanta, this Chenny Buyan was not admitted.
she was admitted
Then why she was required to come to the court?
because her result pursuant to this order, my lords, her results were withheld, my lords.
Pursuant to this, why? But this is a writ petition filed by her. For what purpose?
Writ petition was filed by her because her candidature was put on hold.
Okay.
That is the reason why.
So they were holding a verification exercise on their own.
Own, my lords.
Okay. Okay.
My lords, not on own, there was some random complaint, my lords. They acted on the complaint and it was withheld.
Okay.
So 33, my lords, the Honorable Single Judge, from such point of view, we refer the matter to the state level caste scrutiny committee to give an opportunity. Now it was referred to the state level caste scrutiny committee. Now, my lords would come to
The report affidavit
before the affidavit, no, just one page, page 24, my lords.
of this very application.
This very application, my lords.
Yes.
How the committee dealt with my lords, how the verification was conducted. It was not the fault of the committee, my lords, because it was circumscribed by the Honorable Single Judge.
Yes.
My lords, in compliance with the Honorable Single Judge Guwahati High Court order in so and so, dated 19/9/2023, you are directed to appear before the state level scrutiny committee for verification of your caste status and TGL, XTGL category status and so and so, so and so, so and so. Lordship would refer to paragraph number 4 below, my lords. One certificate from the manager of the tea garden, where her father, forefather, predecessor worked. You know, the migration started in the year 1830, my lords. Tea garden laborers. And if my first generation was a tea garden laborer, I'm still an XTGL, my lords. And I have also shown the law, my lords, by which the plantation labor rules, the records shall be maintained only for 3 years, my lords. Now, my lords, the inquiry was conducted in a preconceived manner as per the order, my lords. Now, lordship would come to the affidavit, my lords, the inquiry report.
Let's see affidavit. 29 May.
Inquiry report.
Yes. यही तो है ना? It's not the affidavit. हाँ वही दीजिए ना. Give that. Okay.
The present applicant had to face the burnt of the order, my lord. She was not even a party, my lord. She was never informed. Last stage after getting admission, she was page 198.
198.
Observation and findings of the state level scrutiny committee. First column is the serial number, second column name and address, third district, fourth, my lord, the OBC category, fifth, the document submitted so and so before the SLC. And my lord, the next column, the report submitted by the deputy commissioner, whether the certificate issued by the management of tea garden is genuine and duration of service so and so. I'll directly come to my client, my lords. My lords would find that at serial number 17 at page 92. Smita Kumari Mahato.
Serial number?
17.
17.
My lords.
Yes.
Smita Kumari Mahato, Kamrup, OBC, Mahato Community, XTGL. Certificate for XTGL community issued by the ADC Kamrup so and so, caste certificate issued by the DCU so and so. These were the requirements as per rule, my lords. They do not say that these are false or fabricated. Now the remarks column, my lords. Since no document found in support of her claim X as TGL, XTGL hence cannot be accepted. Now how could I furnish, my lords?
The others have submitted. Some of them might have submitted.
Some of them have submitted. Some of them could not submit, my lords. Because that was not a requirement, my lords, as per law. Now the question arises, my lords, what relief can be granted, my lords? I have already, lordship has produced the judgment the other day.
Beyond 2 seats, nothing can be done. How many have gone out?
Two are still vacant, and the judgment gives powers to the honorable court to even create seats if required.
Not beyond 2.
Not beyond 2. Creation not beyond 2.
Yes.
And the last date is 30th of October.
30th October.
So 2 seats are still remaining.
Ms. Saikia, what as per the state, who is the competent authority to issue the certificate?
The certificate.
Yes, as per the state. What is your guideline? What is your criterion? Who issues the certificates?
It is the deputy commissioner and the community's body. There are 2 authorities.
Yes. So the deputy commissioner's certificate,
Yes.
you have authorized the deputy commissioner to issue the certificate.
Yes, Lord.
Do you have any mechanism to doubt that certificate?
We issued it. Then some complaints came from their own community
Okay,
people.
all right. Now in Madhuri Patil,
Yes,
there is a certain mechanism,
absolutely, Lordship.
but whether this mechanism which the learned single judge has devised, is it the part of that mechanism? Tell us
Madhuri
fairly.
Patil, Madhuri Patil, I think, Lordship. It is the spirit we have to take because that is regarding SC, but the same spirit will follow.
Yes, same spirit.
Same spirit will follow, and there are several stages.
Hmm.
Now, what my submission is that, Lordship,
Yes.
one thing is very clear.
Hmm.
The learned single judge found out, in my humble opinion, rightly found out that there was no contemporaneous record to issue that certificate. The DC's whims and fancy will follow.
Then you yourself devise a mechanism
That is why
that it can't be
that
done.
fault has come into the light. Now it is in the domain of this honorable court.
Hmm.
So a genuine person should not be deprived and a non-genuine person should not get it. That is the
Ms.
principle.
Saikia, if that yardstick was to be applied, all your certificates issued by the DCs.
We
be it
accepted
OBC
it. It is not that we accepted it.
Hold on, just
We accepted it, Lordship.
what we are saying that if this yardstick is to be applied of courts testing the competence of the DC to issue the certificate,
No.
what is the sanctity of
Court
any
want-
certificate for that matter? Say NCL. The DC issues the certificate,
Lordship.
and what is the criterion for
You
issuing?
have to see the income of the parent.
That's it. Okay, so there is
There's
a criterion. So for this, if you had prescribed a criterion beforehand, at the 11th hour, or rather we'll say at the 12th hour, whether we can start this exercise.
Lordship, the thing is that we have not, in all cases, we have not initiated on our own.
We don't say whether this exercise at this point of time was required.
That is why I went through the various stages prescribed by the this Kumari Madhuri Patil's case. Lordship. That can be followed here also, now also.
Yes, that's what we propose.
Yes.
That you ignore the observations of the single judge and within 3 days, do an exercise strictly in accordance with Madhuri Patil.
That will again violate the Kumari Madhuri Patil's. Because
Strictly.
certain 2 weeks time has to be, there are certain stages.
So you see, part of the exercise has been done.
Three months period will have to be given if we have to
So
follow.
whether 3 months were done in this one, in this exercise,
Madhuri Patil was not followed. No?
then this exercise is
The
useless.
honorable court had given a specific direction and we are not
That
before
is,
appeal.
that is contrary to the judgment in Madhuri Patil. And that has been done to the detriment of a set of candidates without hearing them.
Now the issue is that in Madhuri Patil's case, Lordship, the student was already admitted and she was pursuing. At the final year, she came.
She is also admitted, sir.
Here the difference, it is at the beginning and Madhuri Patil it is the last stage. There's a fundamental difference.
That is not relevant
That
for
is-
testing the certificate. The mechanism for testing the
If
certificate,
Lordship devised that we have to do as per Madhuri Patil's, we have no difficulty on it. We'll humbly.
but then the process will end, process will be over.
Lordship will only have to observe that after 3 months, if somebody is found not to be genuine.
Then they will be
have
out.
to give up.
They will give up.
That
That's
is what
right.
will be my submission.
Yes,
here.
that's perfect.
Yes.
That's a perfect solution.
That is
Yes.
the only solution. What I have gone.
That's the
through
only,
is that
yeah, we absolutely
3 months,
appreciate.
Everybody
We
will be.
absolutely appreciate what you say.
Yes, Lordship.
Do the exercise strictly in terms of Madhuri Patil,
Absolutely.
and they will give an undertaking
Yes.
that in case
They
the result
fail.
is they fail, then they will
They
have to
will
lose the
give
seat.
up. No sympathy will work here.
Absolutely, absolutely.
In all cases, Lordship.
All cases.
Yes.
Which are those cases of TGL?
My
only?
lords would find it in the affidavit, my lords, furnished by them. My lords, the last page, there are 9 candidates, my lords. Last page, my lords, they have made a chart. The right-hand column, my lords, the rightmost, the affidavit filed by the respondents, my lords.
Yes.
The right column,
Hmm.
list of.
Biplav Kumar, Kuldeep Tasa,
Yes, now, my
Pratishma
lords,
Kurmi, yes.
unfortunately, there are 9 candidates,
Hmm.
but the candidate at serial number 3, my lords,
Hmm.
well, she ended her life after the notification. My lord.
That is why I do not want to argue too much of this case. It's a very sensitive issue. This year, Lordship, in Chennai, 12 students committed suicide because they did not score much in the NEET examination.
Not scoring is a different thing, Ms. Saikia. Having scored, gotten admission, being ousted.
Now who has lost the complaint? Their own companions lost the
Whosoever,
complaint.
whosoever,
And
but-
somebody has managed to
Ms.
get the
Saikia,
certificate.
Ms. Saikia, Supreme Court has laid down a very good mechanism.
Yes, Lord.
Whether that mechanism can be tinkered at the last moment,
That
just to the detriment of the student.
Neither side have argued that point before the learned single.
You have argued,
Now I
you
am
are
arguing,
the,
Lordship.
you are the officer of the court. You will point it out at this.
At this
first
stage, I am
instance.
entering a appearance, Lordship.
Yes. Oh God.
That's why I said 3 months, Lordship will give the timeline.
Yes, we'll
And
ask them to.
Only one issue is, Lordship, who are already there getting the admission, they will also continue. Who are not there, what will be their fate? Because at one stage, we have to look at the number of seats.
Is nine people.
The DME is also.
8 minutes, 8.
How many seats are vacant? If they can all be accommodated and.
So how many are there before the court? How many who have gone out?
Well, there were 4 initially, they were already admitted. Now they are not in the list. Chani, Bhuya, and 3 others, my lords. The first time my lords have passed interim.
One of
orders.
them has ended her life.
Now
She also went out of the
No.
list.
Only Kurmi is no more with us.
Kurmi is no more, my lords.
So she was also originally selected.
Yes.
Originally
similarly
selected.
situated, my lords. After
And
the
after
impugned order, my lords.
22nd, she could not prove her status as TGL Lordship, then her name was not there.
The certificate from the guardian could not be produced, my lord. Because no one issued that.
Now 3 months will be sufficient to
3
produce
months,
everything.
whatever evidence is to be collected,
Yes, Lord.
the entire process
Yes.
has to be carried out and strictly in accordance with no new parameters
Lordship.
to be fixed by the court. Absolutely. Honorable Supreme Court has done it. Who are we to sit over that judgment?
No, regarding the materials to prove their background about tea garden working, Lordship, that document can always be asked.
That can be
Without that
asked.
the Honorable Court's order also. Some contemporaneous record.
We
If I
understand.
say my grandfather was working,
Yes.
some document, maybe a salary slip, maybe a photograph in the garden.
Whatever. Yes.
Lordship,
3 months time would be sufficient to
Lordship,
procure the certificate. So we leave it to the wisdom of the committee
Lordship,
to act as per Madhuri Patil,
yes,
conduct the exercise,
Lordship,
give their report, and they will have to give an undertaking.
absolutely, Lordship.
Agreed?
Yes, my lord, we will be allowed to continue their classes. my lord, because we
Yes,
have-
of course.
because
We'll
we have already taken admission with 20 days, we have class, another classes, my lord. We have taken admission on 7/9.
So 3 persons, Lordship, are before this Honorable Court, Rani Nayak,
Yes.
Sahildeep Horo, and Smita Kumari Mahato.
My lord.
And rest have filed cases, but which are not listed till now.
In SB.
Yes, before the single judges bench also, some cases were.
So
In any case, these are the persons. 8
these are
persons.
the persons here, but then the order will govern everyone.
Everybody,
Everyone.
because they are not inside,
Do they have, they are not in.
because
They must have been.
no, if Lordship is.
You see, the title of the list is
List
list of TGL so and so,
Can they
not included
in
in
the final.
final allotment. So initial allotment, they must be there.
Yes, my lord. Pursuant to the inquiry, they were.
But the problem is with Saikia.
Lordship.
Do you have this number of seats available?
That
Ask
is
your
not that
officer.
the TME is with us.
Yes, he's here.
Yes, he is with us.
How many seats are, you ask him. You ask him.
TGL is all filled up, Lordship.
In any event, the vacancies can't be carried forward.
Lordship.
So how many vacancies actually are?
This, what is
STP.
STP,
One STP.
STP.
In one, he was saying
All India quota.
all India quota.
All India quota, we have already requested the central government to allow us to fill it by the unreserved category, but no response from the central government. We
So
cannot
we
fill it
can-
on our own.
We can do it in this category.
I leave it.
We
No
will then.
difficult. That will
But
be,
then also, there'll be only 2 candidates.
yes, then
What
only
about
2
the-
candidates.
Others, you have to provide us the solution. It's a problem created.
Yes, 6 seats will be required, Lordship.
6 seats will be required.
Or else Lordship can give a direction to verify all these. All these. They'll continue with their studies also.
All means
All TGL extra.
all
All
30.
TGLs.
all TGLs.
No, maybe this
No,
night.
Mr. Saikia, we
The
don't want
rest
to,
have already cleared.
we don't want to commit the same mistake the learned single judge.
No,
done.
no, what I am
If
saying,
they-
Lordship,
They are not
they have
before us.
already appeared. They already appeared and got the
They
clearance. from
got the
the-
clearance, no? That's why.
Yes. So
But then-
only this 8,
8, how you will accommodate?
if required next year, maybe Lordship. So those who are already there,
Hmm.
they will let them continue.
Already there means they were in the initial selection.
Initial selection.
So all 8 were, or 9 were there. That's what your list says.
All their seats were withheld, my lord. Pursuant.
They were vacated on account of this court's order.
We'll just, out of these 9, how many were admitted in it?
You let us, because the title says not included in final allotment. So maybe in the initial allotment, they were there. They are, Mr. Saikia, he must be knowing what writ petitions are pending in the signature.
Yes, Lordship.
Which are those?
Writ petition pending.
Lordship, I can furnish them. There are 4 or 5 cases pending.
They must be from these 9.
Yes, from this.
From this.
Instead of preparing an appeal, they moved the.
Writ petition.
They must have challenged that 29th order.
Yes, yes, yes. Yes, madam. As a consequence of the court's order. What is the name? What is the name of the candidate?
Admission
Rashmita.
Wrongly impleted by us, my lords. I thought she
Wrongly.
was at the bottom of the list.
Okay.
But however, she was not even admitted, so.
She has not been admitted.
Struck off, my lord. That would be
We are,
struck off.
we are not passing any order to the adversity of your candidate.
Lordship, one vital fact, Lordship. If Lordship is pleased to come to page 192.
Yes, please. One 192. Yes.
192. So this is the notification of 3/9/2023.
Yes, these 9, the verification has been awaited.
Yes, so up to 20, we gave them admission.
Yes.
Rest were not admitted, their admission was kept withheld,
Yes, awaited.
committed. So we have done the blunder on 30th. After the verification report came in 2022, 22nd, then the 29th order, the Honorable Court said that we have accepted the report. Then we issued a fresh list on 30th and we completed the admission. On that day, they were admitted. So that is how the 30 seats were all. Otherwise, 20 seats were covered.
Or vacant. Those,
10 were-
these
10
seats,
were vacant.
these seats were lying vacant.
Exactly,
But
Lord.
after the verification exercise, which is apparently not as per Madhuri
Yes,
Patil,
Lordship, and that report was accepted by the learned single judge on 29th.
because this issue was
Whatever
never
may be,
pointed out.
Lordship, but he cannot bypass the Honorable Court's order.
No, he has no capacity. to do that. We don't fault him at all.
Yes. So when it was accepted, then because 30th was the last date.
Yes, we understand.
So last day, we do not want to lose any seat, but we have violated this Honorable Court's order also to some certain extent, for which we seek unconditional apology, Lordship. That there's a stay of that order, but we somehow.
After the stay, you gave admissions.
Because I have asked him, Lordship, they received the read appeal copies and etc. Not specifically, and on that day, they could not go through everything.
Council was
here.
appearing.
And there was a miscommunication.
So that is the ground on which we can grant admission to these.
I fully agree.
Because
we
there
take
was
the
a-
responsibility for
Yes,
that,
yes.
not the officers.
All right.
And my
No,
lord,
no.
I may just point out just one thing last, my lord.
Yes.
These 8 candidates who were ousted, they are perhaps more meritorious than the people who were included in their places, my lord, because they were higher on merit.
Merit is not, obviously, that's why their names were included
Yes.
in the earlier
So
provisional
these
list.
8 people who were admitted in
All
our
right, we'll,
place.
we'll prepare the order and show it to both of you.
Yes, Lordship.
Just-
What my suggestion would be that let us complete the exercise.
Yes.
And if there are some additional seats required, next year it can be carried forward. With that observation, I don't think from 30 seats, 4 or 5 seats for subsequent years admission can be given to this because of this peculiar situation.
See, 2 plus 2 we can account for right now.
Absolutely, Lord.
Right, 2 plus 2 are available. 2 being increased by the court's discretion as a
Yes.
consequence of that
Yes,
judgment.
Lordship.
And 2 which are lying vacant. So the 3 appellants are here before
Yes,
us.
Lord.
For the remaining, we'll say that,
And they may not clear also. And after 3 months, we will know.
yeah,
whether they are
we don't know. So for them, the decision can come.
Yes, Lord, at
after the
that
report.
appropriate point of time.
Appropriate.
Let the appeals be kept pending also, Lord.
Yes, we'll keep the appeals, madam. But they'll have to furnish the undertaking.
100%, man.
Yes.
But lordship, this medical admission will be allowed to attend classes, man. We're missing classes.
We are passing the order today.
Yes. I'm very
Wait for a
grateful, my
while.
lord. I'm deeply obliged.
Yes. What a mess has been. Mr. Banta, we need you to give a brief synopsis
My
of
lord,
the entire sequence of events, including this court stay order
Yes.
and the subsequent issuance of the select list.
yes. List of date format, my lord.
Yes, yes. So we'll make an observation that there was some confusion
Yes,
as per Ms. Saikia.
Lordship,
The authorities could not understand the order. So
Lordship.
we will not also burden them.
Because
They're
they could
obviously-
not go through the read appeal and everything. That was the last day of completion of
We will not,
this category, other categories also.
it's okay. It's not a case wherein anyone can be held personally responsible.
Lordship.
But that is very painful, that child losing a
Yes,
life.
Lordship. That is why we do not want to,
Really,
we are not taking this litigation as an adversarial litigation.
really painful, really painful. Candidate having been selected, losing out without being heard, that too. That is the worst case of being condemned and heard. What about the family?
Highly obliged.
Which one? ठीक है, लग दो। देखिए। Password matter.
Passover method 2.
My list is gone that side. मेरा list सब चला गया। File में चला गया।
May I pleases your lordship,
Yes.
pertaining to your lordship service of notice, your lordship. We have received the service of notice, your lordship, that has copies has sent to the department, your lordship. We are awaiting for their response from the district officer. So kindly, Madam.
Council MS so and so states that the notices required to be served upon the response number so and so have been forwarded to the district office, and the report is await return of notices for 2 weeks. Okay.
Obliged.
Deeply obliged.
देखना वो पंच में चला गया होगा। ऊपर बंच है एक जगह। चलिए चेक कर लीजिए। Give me another list.
Passover
Yes.
method 12.
Council is here.
Yes.
Yes.
I'm extremely sorry for not being present. but
All right.
it was-
What do you have to say?
Lordship. My humble
Your
submission-
client is so special that she gets an extra leverage in the ratio of the candidates to be invited, and then she gets 21, 22 marks from everyone.
My selection was based on as per resolution dated.
Now that we'll see.
2015.
We'll examine the validity of that notification.
Challenged by the petitioner.
We'll examine the notification. Don't worry.
And further,
Yes.
the another selected candidate, Biddu Sharma, he was not even.
He was not, because you were brought in illegally. If the ratio was 1:6, you would not have come in.
1:4 was.
1:4 on the basis of a government notification which does not exist. Right? There's no such government notification. All the notifications, guidelines of the APSC are 1:3. Nowhere 1:4 is provided. It's apparently an exercise to give advantage to your client, nothing beyond that.
My lord, the only submission they are making is that I have not challenged. My lord, on what background I have not challenged? Because when, my lord, these minutes of the meeting was not notified, it was not there. I was under a bona fide impression that since in the merit list, which was published after the written examination, my age was written 39. So I was under an impression until filing of the writ petition that it is because of this 39, which was wrongly there, because 38 was the benchmark, my lord. I was under impression that it's because in the merit list, my age was shown 39, because which is why I am not, my name does not figure out in the final selection.
What is the age limit?
Age limit is, my lord, 38 years, my lord.
38. So otherwise also you, how would you get in?
My lord, no, I am within they have wrongly typed my.
Wrongly typed.
Wrongly typed. Then I have clarified the point.
Okay. Very well.
Therefore, since it was not published, so I did not have an occasion to challenge it, my lord.
Okay.
I am deeply.
Yes, Mr. Bora, you have to say anything? No. You will dictate the judgment? Okay. Arguments or judgment resolved.
I am deeply.
Passover method 24.
Where is Mr. Saikia? That grid file has come now. Let's see.
As per the guidelines, my lord, the OBC NCL certificate has to be obtained from 1st of April 2022 to
Just
1st of
let us see your writ petition.
31st of March 2023, Lord.
Just. There's yet another earlier writ petition which he filed, 4510. ठीक है. 4510. When was 4510 filed? Do you have any idea? Yeah, they have not annexed the copy even. You have implemented the candidate? You have implemented that candidate?
Yes, I have included.
Who is there for the, or that writ petition stands disposed of?
No, that only notice was issued, my lord, in my case.
In that writ petition, the writ petition filed by Simarani Das.
That was disposed of, my lord. On the same day, it was disposed of.
Not same. Get the file of Ms. Jackie. Get the file of writ petition number 29/6/23. Sorry, 4510/23. 4510/23. Decided on 30th August 23. Oh, sir, certificate of 17 June is OBC simpliciter. Yes. Yes, Saikia.
Lordship.
The certificate which he was holding on 17 June, that
Lordship.
candidate
Lordship.
is simply OBC.
NCL was not there.
Not there. This is certificate. So she could not have applied under that category. The judgment, you have a look at this judgment. And the one on 9th October,
Lordship.
probably the copy has not come out, has not been uploaded.
It has not
That
been
would-
uploaded.
That would conclude the things. Ms. Chetri will have to hear the other side. Without that, it can't be done. Because she is bound to lose the seat. So we'll issue notice, ask the concerned superintendent of the medical college to get the notice served.
Lordship.
IA we will allow, of course.
Yes.
IA for leave to file appeal allowed. Take down in this one. The applicant is aggrieved by the judgment dated Oh, this is for the stay of the order. Okay. 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 So you were not granted interim order, that's why you have come.
Yes.
The petitioner is aggrieved by the appellant is aggrieved by the selection, the admission of the respondent number 5. It's not like this. The pursuant to the NEET UG test 2023, the appellant herein applied under the category of OBC NCL in the revised provisional Assam state merit list of NEET UG dated 24/7/2023, the appellant applicant ranked at 2675 in the OBC NCL category. The respondent number 5 being a OBC candidate, applied under the general category and her rank was 1133. Full stop. In 3 rounds of counseling, the appellant herein could not be admitted. However, in the stray round, within bracket 4th round, the appellant herein was selected by provisional select list dated 28/9/2023. Immediately on the next day, the respondent number 5 was accommodated on the seat of the appellant herein, occupied by the appellant herein as per the select list dated 29/9/2023. Full stop. It appears that in the intervening period, the respondent number 5, preferred writ petition number so and so 5730/2023, staking a claim for consideration of her candidature under the OBC NCL category, and based on the direction given by the learned single judge by the judgment dated so and so, the said respondent was allowed to change her category to OBC NCL, and as a consequence, being higher in merit as compared to the appellant, she has been admitted on the post, on the seat earlier occupied by the appellant. Issue notice of the IA as well as the writ appeal to the respondents. And Advocate General Saikia puts in appearance on behalf of the state authorities as well as the Principal Kokrajhar Medical College, response numbers 1, 2, and 3. Service upon the respondent number 4, Union of India, be effected by providing copy to learned Deputy SGI, Mr. So-and-so. Service on the respondent number 4 be effected through the Principal Kokrajhar Medical College, Kokrajhar. It shall be the duty of learned counsel. What's your good name, sir?
Well, B.
Gogoi, to ensure that the service of notice of this appeal upon the respondent number 5 is got effected on such respondent through the Principal Medical College, Kokrajhar. List on 17th.
Deeply obliged.
In the meantime, Mr. Saikia, have a look at both the judgments.
Lordship.
What is the effect thereof
Lordship.
on this notification? May unnecessarily create complications. We don't know. The registry shall tag the files of writ petition numbers 541 so and so and 5730 within bracket disposed of, both disposed of matters with this writ appeal, and list the matter again on 17th.
Highly obliged. Would it be on 16th, Lordship? 16th.
It can be on 18th if you want.
Lordship, from 17th, I am in the Supreme Court day-to-day hearing of the constitutional bench matter.
All right, let it be on 16th then. 16th.
Date is fixed 17th, 18th, and 19th.
Okay, let it be on 16th.
The citizenship.
16th. Yes, yes. CAA.
Lordship, not CWA. Section 6A of the Citizenship Act.
Okay.
That is okay. Highly obliged.
So there's also a matter relating to NRC. NRC also going on.
NRC and CA are totally different. There are about 200 other cases. This is about 6 cases.
Okay.
Tagged together.
Right.
Only one issue is to be decided.
Okay. There.
Daily list, item 19.
So in this case, the government has already placed the records there.
In view of the earlier order, my lord, we have filed a response to the order dated 22/8/2019, my lord. That is, I have seen, my lord, it is not in the record.
So only on yesterday, lordship file, though.
All right, bring it on record. Learned Council representing the private respondent number so and so submits that he has filed an affidavit yesterday.
Yesterday. Yes,
Let this be brought on record. List on
Friday, lordship.
Friday. Okay.
Published.
Item number 22.
Your lordship recollect this matter where your lordship, because our whole case was no notice was served.
Now let them go after.
Lordship, may I make a prayer, your lordship? Since your lordship earlier, your lordship, honorable single judge, your lordship, directed the matter to be decided by the labor court, your lordship, and also directed the respondents, your lordship, to deposit 25 lakhs rupees so that we can take as an interim measure, your lordship, that amount, your lordship. That has been put to silence. If my Lana Senior Council is agreeable to a proposition that let the matter go to the labor court, your lordship, and the amount of let it come after vacation, we'll
Take instructions on this.
Yes.
Then Council, Mr. Botakur has submitted that the ends of justice would be served if the matter is remitted to the labor court without insisting for the deposit.
Deposit, you already deposited that amount, maybe your lordship. We will pray for that. We will see after reopening of the matter.
So what do you say to dispersal of the amount?
No, let it come after reopening of the matter, my lord.
All right, then, as jointly prayed, placed after the ensuing puja vacation.
Item number 23.
A date may be fixed, your lordship.
29th, 30th November. Okay.
This paper may be taken at 2. Maybe taken at 2.
At 2?
My lord. Can it be?
Then let it come up on 16th if there is so much of urgency. Is there any urgency in this?
Not, sir, not exactly.
All right, then let it come after puja break. After puja vacation.
After puja lordship. That's the interim order lordship that will be expected.
Interim order shall continue.
Date, my lord.
Will come up automatically. All right.
Daily list, top of the list matter, item number 1.
My lord, this is for final disposal, my lord. Special settlement.
You are enjoying.
I am enjoying.
I am not enjoying. I am not enjoying. He is enjoying.
You enjoy the puja vacations. Now we have passed a detailed order in that matter. Let it come up.
Maybe on a fixed date.
Now we'll give a date, sure. 16th.
16,
November.
so many matters. 18,
November,
my lord.
November.
No, 18, my lord.
18th is Saturday.
Oh,
20, then let it go on 28th.
yes.
Okay.